Hello, welcome everybody. We are delighted to have the audience today as well as our esteemed speakers. The topic of our discussion today is due diligence and documentations, key issues and enforcement. I will start with a few introductions. It'll take me a couple of minutes. So I'll start with an introduction to the host, which is the firm of Nishith Desai Associates, which is a research and strategy-driven international firm with offices in Mumbai, Palo Alto, Silicon Valley, Bangalore, Singapore, New Delhi, Munich, and New York. Its team comprises of specialists who provide strategic advice on legal, regulatory, and tax-related matters in an integrated manner derived from key insights carefully culled from allied industries. Nishith Desai pioneered the field of international taxation and asset management in the private equity industry. NDA advised Mauritius and more recently conceptualized the Gift City financial centers. Nishith Desai Associates has engaged in private equity for over 3 decades and is a thought leader in private equity and legal matters relating to several other areas, including technology. NDA has remained in the forefront of advances in these fields and has been awarded the Asia's most innovative law firm by the Financial Times for 4 years in a row. Given NDA's deep involvement in private equity, it provides invaluable insights for the benefit of its clients, the ecosystem, as well as regulatory bodies. Many of these insights are published regularly and can be accessed via our newsletters and special reports available on NDA's website. I will now introduce Mr. Desai. Nishith Desai is the founder of the research and strategy-driven international law firm, Nishith Desai Associates, ranked amongst the Asia Pacific's most innovative law firms by the Financial Times. Nishith's interests span a wide spectrum of law, society, and ethics. He's a renowned international lawyer, author, lecturer, researcher, and a thought leader. Nishith himself is regarded as the father of international tax in India and is a true pioneer in the field of international tax law. He was also a director on the board of Singapore International Arbitration Center. Soon after India opened its economy to the outside world in 1991, Nishith pioneered the roots of the asset management industry in India. He established the first 5 India-focused funds. He played a seminal role in structuring several private equity funds, in addition to structuring several domestic venture capital funds. Nishith has driven the conceptualization and creation of Imaginarium Aligunjan, a state-of-the-art research facility that stands as an ode to blue sky thinking near Mumbai. I would now briefly summarize the resumes of our esteemed speakers today, the esteemed panelists. We have Mr. Uday Dhawan, who's an MBA from the Wharton School. He is the founding partner and head of India private equity at Affirma Capital. Prior to this, he was the managing director of Standard Chartered Private Equity since 2008. He has made some seminal investments such as Cafe Coffee Day, Endurance, Fortis Healthcare, Northern Arc, and some others. His prior work experience includes JP Morgan, Kotak, and Arthur Andersen. He was also a member of the executive committee of IVCA. We also have Mr. George Antrappen. He's the managing director of DC Advisory. He covers information technology services and enterprise software sectors. He's a co-founder of the India practice in Bangalore and has 15 years of investment banking experience. Vaibhav Parekh. Vaibhav heads the US and the US offices of NDA. He leads the tech, telecom, M&A, and PE practices in North America, and he's also been a key advisor to cryptocurrency exchanges. We have Huzefa Tawawala of Nishith Desai Associates. He heads the Bangalore office of NDA. He's particularly playing a key role in disruptive technology areas of practice. He has worked on drones and artificial intelligence. He has also been a member of the Government of India's task force on drones, as well as been involved in several inbound and outbound M&A transaction. Now, before I hand over to Webhub, who will moderate today's session, I do want the audience to know that this session will continue till 6:30 p.m. And after that, you can still remain on. There will be what is called a coffee corner, where you can network with the Nishith Desai Associates lawyers. Over to you, Webhub.
Thank you, Arvind. Thank you so much for introduction and welcome everyone. Today's topic, as Arvind mentioned, is on due diligence and documentation. Generally, what we see is, it's a mundane topic. Sometimes it's considered to be a necessary evil by both companies and investor. It's something which is a tick box, needs to be done. But in our experience, what we have seen is that turned out to be a lot of strategic value out of due diligence and even on documentation side. When you look at from strategic value perspective, we have seen people kind of realize that hey, it's not worth investment, or they have sometimes changed the structure for investment. Sometimes they have set and revalued the organization. Sometimes, if nothing else, at least they have gone in with their eyes open on what they are getting into. So we have seen due diligence turned out to be a very, very useful, valuable parameter. And today's discussion is trying to find out from practical perspective how it works and how it helps and what are the key issues what you find. Similarly, documentation, which includes, your subscription agreement, your share purchase agreement, your shareholders agreement, or in related agreements, and we will try to just look at it. What are the key values which the investors and the companies get out of that? So this is basically what we'll be doing today, and we have a great panel today, and maybe I will just start asking Huzefa the first question. Huzefa, let's start with due diligence, and why don't you talk about the key consideration and issues one needs to look out in legal due diligence?
No, absolutely. Thank you so much, Webber, for the introduction of the topic and this question. I think the approach to due diligence has also changed. And it has gradually changed over the years. It's not like the tick the box approach or something which needs to be done before looking at a company, right? Everything has become more objective driven and more, what is the value add which can come out from an exercise. So I think the key parameters when you're looking at undertaking a diligence, I think the first is to understand what is the business of the target, what is your objective in investing in the target, right? So for example, if you're looking at a target which is a platform company relying heavily on services and which has a heavy customer base. So from a business continuity perspective, customer contracts obviously become very important. Change of control clauses in customer contracts become important. Liabilities and exclusivities and MFN clauses under those contracts become important. But the approach will be very different if you're looking at any objective of investment in a company is, say, for the product example, or it's for the R&D, right? Then the entire contours of the diligence change. Your technical diligence is also going to be very different. It will be more in terms of validating the veracity and the viability of the IP, for example, or chain of title and how the IP was developed, whether it was co-developed, third-party sharing, third-party rights. So the approach again kind of varies differently. Of course, the other aspects of the diligence continue to be important. The instruments which you get or which you kind of, whether it's a primary, secondary, and how you acquire them. The other trend which we've seen, it is slowly getting more and more interesting, are the softer aspects of the diligence. So the core aspects of the diligence, whether it is litigation, regulatory, registrar of companies, all those keep continuing, but the softer aspects when it comes to companies is getting more and more important. For example, ESG, right? Environmental, social governance standards while looking at businesses is also getting extremely important. We've had some incidents in the recent past, whether it is the NSE. We have seen certain clients which are not comfortable investing in companies which are in the field of sin goods, or which are heavily reliant on, toxic waste and those sort of things. So the ESG angle itself is getting more and more prominent, and we have a series which we're going to discuss it separately. The other softer aspects getting more and more interesting are reputational risks as well, whether it is reputational risks of the promoters or the company, and how comfortable do investors feel, being associated with such companies. So these softer aspects, the third, which is getting more and more interesting, there's already a wave in the West when it comes to gender parity, gender diversification. So those sort of things are something which are being looked at, from an investor, from a private equity perspective in companies. It's not that all deals are doing that, but this is the trend which is definitely going beyond. So to sum it up, it's not just the tick in the box, which historically used to happen. It is more and more objective, and surrounding areas in relation to the softer governance aspects or environmental aspects, are also gaining more and more traction. Back to you, Vaibhav.
Thank you, Zefa. That's correct, right? Things are evolving, and the due diligence is also evolving. A lot of things what we should have done earlier is sometimes now taken for granted, or done very quickly using computers and stuff like that. So due diligence now is more on software aspects also, and trying to figure out on various other things of how being associated with this company will affect my reputation. And Josefa rightly talked about ESG. That just reminded me of a transaction where investing in a company which is known for having good corporate governance practice, right? The pride in association with that particular company was very important in the eyes of the investor. And in some situation, I remember a case where the investor was in this company or not, the promoter's reputation is not that great when it comes to being good on his word and being good on the governance side. And if I invest, how will my reputation go with it? So reputations also have been very, very important in taking a decision on whether should I invest or should I not invest. Also, what happens is that due diligence, when we come as lawyers, when we come with a due diligence report, there are hundreds of issues which we find, right? Sometimes they are small issues, very, very small issues, but as lawyers, we are obligated to find out, whatever problems they have. And every company is not perfect, so there are issues involved. But there are only some issues which are very important and critical. Other issues may not be that critical, and that's where the categorization, whether this issue is an important issue or it is not an important issue, right, which comes into picture. And often that is very important from investor perspective. And I would like to ask Uday, how do you read due diligence report, right, or due diligence document? What do you expect from the advisor? And do you expect, this categorization of what is important, what is not important? And, can you give some idea of looking from the eyes of investor on diligence perspective, what do you look into it?
Sure. Thanks, Weber. Firstly, pleasure to be here, and thank you for inviting me. Look, I think, when we look at diligence, I think we look at it from a holistic and an integrated manner, right? Because if you just look at different pieces of diligence, there's legal, accounting, more commercial, it could be ESG, forensic, etc. At the end of the day, for us as an investor, it is about connecting the dots, right? You look at multiple streams of diligence and then try to make sense out of it as to where are we coming out in terms of our comfort level in going ahead with the transaction. So even when we are looking at legal diligence, one of the things we always try to do is we want all our diligence providers to interact with each other, right? Because as you not just share reports, but interact with each other, talk about it, because as there's more engagement, the financial DD guy may have found something that may be relevant to the legal guy or the ESG guy, and so on. And we also share the commercial thinking with the lawyers, because at the end of the day, assuming you're taking the decision to go forward, everything needs to be captured in the legal agreement and the documentation in one way or the other. Either you're comfortable with it and you choose not to capture it, or if there are certain issues to be addressed, whether it be through CPs, CSs, shareholders' rights, etc., etc., there needs to be some way to account for it. So I think the approach is holistic, it is integrated. Also, I think the point that Huzaifa made is an important one, which is it has to be viewed in context, right? So what kind of company are we dealing with? So if you think about an early stage company, the level of diligence is very different. I mean, when the market is hot, it's very light diligence. A lot of earlier stage companies, VCs, do very different kind of diligence. We are a more mid to late stage company, so we like to spend our time, because typically the companies we invest in have been around for a while. So there is also enough data to look at. So it also really depends by industry. So if you're looking at a financial services deal, we really expect the DD providers to have diligence at least another 5-7 other financial services companies, because the ability to discern issues, if you're not specialized, I think is going to be very difficult, right? And the kind of issues that come up are difficult. So, I think to summarize, we take diligence very, very seriously, and it's almost like you think about a whiteboard and there are like 10 different circles where there are all different kinds of diligences, and it's about really putting everything in a bowl and kind of churning it, and to see where do you really come out of it, because at the end of the day, it is a judgment call, and you've got to be practical. There is always a pressure that you need to make investments, but at the same time, the quality of investments that you make is super critical, and governance, is again, there's a premium for governance in India, right? So people are happy to, we've always paid a premium in terms of valuation, where we feel, the promoter, the reputation of the promoter kind of reflects that governance. So I'll pause there.
Thank you, Uday. And I just wanted to add to what Uday said, and something which my experience suggests is that from when investor is looking at a diligence report, and Uday rightly said, right, for him, it is not just a legal diligence or a financial diligence. He kind of integrates the business diligence, the technology company, the diligence, the financial diligence, legal diligence, all the diligence together to make a judgment. And I think Uday used the right word, to judgment. Should I invest? Should I not invest? Should I invest in this particular method? What are the things as an investor I need to keep in mind for making those investments, right? So that is the key aspect, and this is the expectation from investor perspective, right? And from reporting perspective, if an advisor is giving suggestions or input to the investor, what is really important is how do you analyze, how do you bring out what is in the top value or for the investor, right? What is something which he will find to be most important, right? Where you want to take some action, right? As opposed to list of other things which are there, which can be gathered, but it's not that critical, and something which needs to be kind of put in documentation or taken care of after investment, but it may not affect his decision of making investment or how making investment or renegotiating the deal or those kinds. So creating that value for investor is very important also from advisory perspective. Let me go to the next topic here, but before I go to the next question, I want to just remind the audience that if you have any questions for any panel members, there is a Q&A kind of a box. You can just put your questions in the Q&A box. Last 5-10 minutes based on the questions, I will take up those questions either during the session or at the end of the session. So please make sure that you post your questions if at all there are any. But with this, let me move forward into asking question to George. George, you've been actually helping a lot of companies, right? And in preparing for diligence, in creating, and there are several kinds, right? You've seen situations where there is a single investor with a single company, that you have seen a situation where there's a bid process. Can you explain how about different approaches which are adopted, right, by companies, especially in times of vendor diligence, when the bid process versus non-bid process, what exactly goes into it?
Sure. Happy to, Vaibhav. And first of all, thanks India team for the opportunity to speak today. So I think as an advisor, the approach to diligence probably starts when we sort of decide on the structure or the design of the process, if I may. So like you rightly mentioned, if we are taking a sort of a larger opportunity to the market where we expect it to be sort of a bid process where you have multiple stages of interactions with counterparties, we also need to design the rest of the process around diligence to sort of be aligned to that, right? So in a two-stage bid process or in any form of a bid auction process, responsiveness and being ever ready is super critical, because as a banker and as a company, we are pushing counterparties to respond within timelines. So the last thing that we need is being underprepared and or taking more time to respond to diligence queries, right? So I would say the approach fundamentally varies in the amount of, I mean, there is a level of preparation that goes into any transaction, but especially so if it's a bid auction process where you're really managing it on tight timelines. Secondly, I would also say that the approach to diligence, where it's more an investor-led or a buyer-led diligence, is more comprehensive, while on the investor side, it's more a issue-based report, if I may. But when you're doing more a sell side or a VDD, it becomes more a comprehensive report. So especially if it's a regulated sector, there needs to be a coverage on what are regulations that govern, what are implications on the company. So there has to be a little bit more background material as well, which are included in diligence report, which makes the reader more sort of able to appreciate the business better and form their views on it, right? So I think first and foremost, I would say the level of preparation and the coverage being more comprehensive are probably the two fundamental differences in terms of approaches, whether we're doing a larger bid auction process to more sort of narrower bilateral/limited party process. Lastly, that I would also add to this is in terms of approach, what also matters is, again, depending upon what the shareholder construct, whether we have financial sponsors on the cap table, also an alignment on, well, we'll be talking about indemnities and reps and warranties later, but sort of a discussion and an alignment on how we are providing backstop for indemnities, specifically if you're thinking about an insurance structure. Again, becomes relevant as we think through diligence, because as we all know, that's another work stream that needs to be managed, and hence if that is being proposed as part of the transaction, there needs to be preparation and alignment to be able to cater to that as part of the overall timelines as well. Let me pause there, Vaibhav.
Thank you, George. It's very interesting because a vendor-led diligence is company's own diligence, and often company then often realizes that, hey, I should have taken care of this issue and I should have taken care of the other issue. They didn't realize that there are issues in the company, and often they start the rectification process, while the diligence is still being done or while the process is going on, and that makes company a better fit for being able to get an investment or do a transaction. I have seen, and this is something which somebody was telling me in the industry, that once we did not do the vendor diligence, and it was buyer which did the diligence, the amount of issues they found and the kind of impact which it had on the timeline of closing the deal, or the complexity which brought in the documentation, there was an observation made at the end of the day saying that wish we had done a vendor diligence on this particular transaction. We would have rectified and life would have become simple and faster. So often there is a kind of a discussion, and something which we need to keep in mind, that vendor diligence means that company is ready to kind of prepare itself for the transaction much earlier compared to diligence by investor. And often in a diligence by investor, sometimes I have seen that the company does not have a report in hand, and as a result, only when the investor starts asking for indemnities is then when it comes to know that they had a problem like this, right? And then if they have to react. So often that kind of strategic decision need to be taken by the company, but let's move on, considering the time, let me move on to now interesting aspect on the documentation side. The interesting aspect of documentation, what I find is actually negotiations. It's a very fascinating situation from negotiation perspective, because negotiation is such, right, that where you sit in a document on the other side, when it needs to come that if both parties needs to do a win-win situation, and come to an acceptable thing where both parties feel that they have got what they wanted, but they also have to make sure that they don't give something which tomorrow they kind of regret, right? So you need to come to a delicate balance of something which both parties get what they want, right? And often that process of diligence, negotiations, is very interesting, because you start with something with a position at one level, and then you come in between, and the same thing happens with the other side. And sometimes, having done like 100 negotiations, I feel like, why can't we straight away go to the position where we all know we're going to end up with, right? Instead of starting with a different position. So, it's a very fascinating process, and I will maybe ask Huzefa, why don't you take up this negotiation and topic, and just tell, what are the strategic decision one needs to do when you sit for negotiation?
No, absolutely. I think this is, for most lawyers, this is a very fascinating topic in terms of negotiating the interests, of course, of your client, but also ensuring it's kind of balanced. So it goes without saying that, the approach has to be balanced. It can't be lopsided. It goes without saying that, avoid boilerplate agreements, know from a client perspective what you want, important of soft skills. But of course, from a COVID perspective, when everything was virtual, it was difficult to actually gauge the pulse and body language. But having said all of that, we all would have been in situations at the end of it there are open issues. Ultimately the negotiations finally boil down to those X number of open issues which are there. So what we've done is we've kind of made this interesting. It's not like a management session, but we have a slide for y'all where we actually going to take an approach on negotiations basis a risk probability theory. So let me just share the slide right away, and then we can deliberate this further. Give me a moment. Yeah, I think the slide is visible, right, to all? Yeah. So
Yeah.
I think so this slide was actually done by the moderator Weber himself, and I'm actually going to present it. So the way ultimately, after all the negotiations, people have been wanting to close the deal. Say there are 10 open issues, and open issues will always be there in all deals, and that's where we thought we'll take a different spin off from an approach perspective. So this is a slide which essentially has 4 grids, and we can categorize issues and our approach based on the impact versus probability theory. And believe me, this has really helped. Then when you have a break-off session with X number of issues open, you go back and you kind of apply this matrix. It makes life much simpler, especially from a decision-making perspective, quantifying liabilities, understanding giveaways and takeaways. So without further ado, the first right side box which is there, which is H impact and probability H. So what does that mean? It means that this is the issue where the impact is also very high and the probability of this happening is also very high. Essentially, these come under the buckets of deal breakers. Now, when it comes to deals, you know, issues falling under this bucket would be very few, unless and until there is something which is drastically wrong with the company. So simple examples, you know, for a impact versus high impact and high probability is that if you're doing a secondary from the promoter and the promoter share title itself is questionable, right? Now, the impact is very high because the value immediately gets impacted when you kind of, you know, acquiring those shares, and we are assuming that, you know, they cannot be remedied, or, you know, someone has passed away and through inheritance, you know, there were some other claimants as well to those shares and those sort of. So the impact is very high and the probability is also very high. It's equally high when, you know, you undertake that particular issue. So this comes under the category of deal breaker category. Very few, but impact high, probability high. Moving forward, the other sort of issues is the next top left-hand grid, right? Where the impact is high of that particular issue, but the probability of it happening is very low. So what do you do, right? You don't walk away from the deal. So for example, I'll give an example, right? So if the company has undertaken certain delays in filings, or there are some compounding applications which could be made. Yes, we know that there is an impact, there is a non-compliance, so there is a tangible impact. But the probability of it, you know, kind of fructifying basis practical experiences, basis the way regulators work on ground is low, which means that, you know, you can actually mitigate this sort of an issue, and that can be negotiated through indemnities, you know, taking suitable insurances, playing around with conditions precedents, you know, conditions subsequent. So essentially this come under the category of negotiables, and, you know, there can be a mutual give and take between the parties. So this is one category. Moving forward, the top right, the bottom right, you know, grid on the slide, which essentially is the third category, right? Where the probability of that happening, that issue happening is high, but the impact is low. So this is the reverse from the earlier one. So what could be these situations, right? Where the probability high. So imagine that the company has received a GST tax notice coughing up to pay X number of rupees, right? Now we know that the probability is high because the impact, you know, it is going to happen. But, you know, what is the impact? Is the fine so large that, you know, the impact is high? If the fine is kind of little small, it is a low impact. And again, this risk again can be managed through multiple means. Price adjustment is one, you know, escrow mechanisms are there. So again, it is not a deal breaker. It is a giveaway where you can actually give this away and take, you know, more critical points. And the last one, which is the bottom left, which is low impact and low risk. So essentially these are the ones you don't care, right? They are remote, you know, there could be issues, they could be discovered in diligences or otherwise, but you don't really care. But this grid, if you kind of categorize open issues from a negotiation and strategy perspective, if you go by this grid, internally you will be able to understand what is important to you when you actually on the final table, you know, as a give and take, what is non-negotiable, what can you swap, what can you give away, what can you get. It just makes decision making simpler and more objective. So, you know, this is a summary of the grid. Back to you, Vaibhav.
Thank you, Zephan. You know, this was something which I actually created 20 years ago. I'm glad that it's still being used. But Uzafa, you rightly said, right, that you know, often if you just identify, list all the open issues, and this is actually I've done it for a client of mine where you know, there were, you know, when we started the negotiation, there were, you know, 70 or 80 open points, right, on small points, right? We actually went and did this analysis, and I identified there were only 2 or 3 points which had high impact, high probability. You know, very few points on the other 2 sectors. Most of the points actually were low impact, low probability. And then, you know, we just sat with client to work out what is the best way to kind of give our position to the other side, right? And often what I see is that, you know, when you go with this kind of thing, you can keep your emotion and ego on the side, and, you know, in negotiations, whoever has been negotiation will realize that negotiation is more than 50% managing emotions and egos of all parties, and other 50% getting the right thing, right? So often, as a part of the negotiating team, your job is to make sure you manage the emotions of all the sides and step back, think coolly, what really makes sense, not get a point simply to get a point, right? Simply to prove that, I can get that particular point, what, I'm negotiating on, but to really make sure there's a value in the point what you are getting, right? This is something which will really help, right? Otherwise, there is no point in spoiling a relationship or creating a bad blood, right? Because whatever in the negotiating room happens, and when the investment actually happens, the memories of that may continue for some time, right? And in some situation, it can be long lasting. So how do you manage yourself in the negotiating room is also very, very important. But this is one way of handling it, putting the emotions on the side and trying to use logic or mind to kind of decide how you want to put your position. But let me move forward, Uday, to you. Things have been changing quite a bit, right? And you rightly said, there are boom times where you are a little bit less sensitive. Things are becoming a lot more founder friendly. R&W insurance is coming into picture. So what are different trends or approaches on documentation nowadays? Can you give your experience on how things have changed and what is currently being done?
Yeah, sure. So firstly, let me comment on that slide. It's a great slide, and I guess you're making management consultants insecure by having these nice 2x2 or whatever 4 quadrants. I think to answer your question, look, the good news is if you look at private equity and VC in India, it's fairly matured. You look at, I mean, we've been doing this for the last 20 years, and we've seen whether it be the level of diligence or documentation, it can tend to change with the times, right? So I still have documents that were executed when we did deals in 2007. And when I look at those documents, I can't believe that we actually, wrote those documents because we would never do it again. But a lot has changed. I think people have, there's a lot of experience also in terms of how differences between investors or founders have played out over the last 20 years, right? So, in fact, one of the things we look for also when we are dealing with law firms is when we are looking at our documentation, we also want inputs from the litigation side because we want the learnings of how did things transpire? Is there a way to preempt it if it ever sort of goes down that path, which hopefully it doesn't, but you just need to plan for it. So I think, again, the nature of documentation is quite different in early stage and mid to late stage deals. I'll talk about more mid to late stage transactions. I think while they may have become founder friendly, but I think they've also become tighter in many ways because investors have learned from experience. There is much more clarity that investors have that, listen, I am only going to do a certain jurisdiction for my agreement. That is a non-negotiable, if you had to go by your quadrant, because if you ever get up into that situation where you have to enforce the agreement, you want to make sure you're comfortable with the jurisdiction you're enforcing that agreement in. There is also much more clarity that investors have that exit rights are super important. and therefore we see a very, very clear thought process on what the non-negotiables are on exit rights and what is something that we can live with. Some of the experiences have also been factored in terms of how detailed do you want the document to be in, right? Because the more transparent and the more upfront you are in your discussions and negotiations with the company, and we want to make sure they understand the document, right? Because many times people just want to take the money and move on, and later you realize. So I've seen, at least from our experience, we make sure that whenever we are investing, the founder really needs to understand what is it that he or she is signing up for, because we want to be on the same page, right? So I would say that the documents have evolved over a period of time. For example, if there is a drag right, there is a very good understanding of, is it really enforceable? Is it not enforceable? Is it just a leverage point? Is it is it just to make sure you have a sensible discussion, etc. So everybody has their own view on it, but I think the documentation is much more mature, it's much more seasoned. And yes, I wish that people enter a room saying, okay, we already know where the middle ground is, but lawyers also need to make money. So, and I'm sympathetic to that. So it's fine. And but I think we're headed to a good place. I've seen deals now getting done much faster. Some of the, for example, you talked about the vendor DD process, right? If I think about this 10 or 15 years back, there was a lot of skepticism to say, hey, listen, do I really want to rely on a vendor DD process? Because whoever's doing the vendor DD is conflicted. He's being paid by the company. But over time, I think all investors have gotten comfortable with it. And you talked about some of the advantages of that, which it makes the process much more efficient. It helps companies organize themselves. So yeah, I think given the maturity of the industry, we are at a pretty good place in terms of how the documentation process has evolved.
Thank you, Uday. In fact, what you said just reminded me of incident where little earlier in my career when I used to advise client, and at that point of time, the founders would simply sign whatever you give, right? They will not sit and negotiate. They just want money, so they say, tell me which document I need to sign. And I used to get nervous. I used to tell my client, and look, if he's not negotiating, then he's not even reading what he's signing. If he's not reading, when you try to actually enforce what you want, you will have a surprise. He will have a surprise, and things will go south, right? Please ask them to read. Please negotiate. When there is a heavy negotiation from the founder, right, then we know that this guy is taking the documentation seriously, right? He is really considering that he will actually have to implement it, and he is applying his mind for that, right? So often it's counterintuitive. When you see a high negotiation, it really means that this guy is serious about getting into a relationship with meaning, to provide what actually is written in documentation, right? And if somebody is just signing up, it's a bad thing. Of course, I have not seen that in recent times. Recent times, the founders have become savvy. They've got advisors. They will actually write. Things are very, very different now. But earlier, things were very different. They never even got an advisor. Just simply say, "I want my money." That's how it is. So that let me move ahead and come to the meat of documents, right? A lot of time when you're writing, everybody wants to know what is my liability, what are the representation warranties. This is one topic which I have seen being discussed in every let's say webinar event. They all want to know exactly what is happening on reps and warranties. What is my liability. So Joseph, I'll come to you. Can you tell classification of reps and warranties? How they are actually classified in documentation, and what is impact?
No, absolutely. And just keeping the clock in mind, I'll wrap it up quickly. Uh, all the transaction documents, right? Investor transaction documents have a schedule which is there, whether it's schedule 1, 2, 3. Some people love to read it, some people don't like to read it, but it is a must. It kind of protects investors, it is kind of linked to indemnities and so forth and so on. So typically there are three broad buckets. And within that, there are various permutations, combinations. Reps and warranties largely from an industry practice are divided into three. One, fundamental warranties, right? Those are the warranties which by the very name are fundamental to the transaction, and they are very few in nature. There has been a gradual shift in the industry which has become more and more narrow when it comes to fundamental warranties, essentially linking it to share title, valid authority to execute, company actually validly incorporated, and very limited and core to the transaction. The immediate impact and bearing of fundamental warranties, depending on how they're classified in the document, is linked to the survival of these warranties upon signing and post closing, along with the monetary liability caps which kind of apply, which get segued into the indemnities. The second bucket, of course, being the business warranties, or they're called operational warranties. They essentially, by the very name, they're in relation to the business of the company. They are more operational in nature, and it depends, depending on who is giving them. A strategic shareholder, who is not actively involved, would refrain from giving them. Typically, these are taken from the company. These are taken from the founders and promoters who are in the operations. Again, business warranties, in the recent past, there is a segue and there is a vertical within that, which are called sectoral, business warranties. If depending on the business of the target, if taking the example of Uday, what he said, right? If it's financial services. Now there are very nuanced sectoral regulations and limitations which apply, which need to be specifically called out. Those are specifically and separately woven in those business warranties. Again, the impact of the business warranties is, how long do they survive for from signing and post-closing, and the monetary impact on the indemnity and the liability thresholds. The third, of course, are the tax warranties. Tax warranties, though part of the business warranties, but are treated slightly differently. One sole reason being that it is specific to taxes, annual returns, filings, GST payments, if it's cross-border transfer pricings. But more importantly, the survival period at times varies from those of business warranties, because statutorily, the taxman in India can go to the company depending on whether it's withholding taxes, whether it is normal filings. The periods, the look back periods kind of vary. So this is the broader impact which is there on warranties, and ultimately that's kind of woven into a disclosure schedule. Those are exceptions to the warranties, within which the moment, if it's part of the disclosure schedule, then you cannot kind of raise a claim if the warranty goes bad or if the warranty is breached. Very quickly, for fundamental warranties, usually we've seen that disclosures are not accepted. The disclosures are not general disclosures. They kind of get pegged on two particular warranties. And when it comes to specific sectoral representations and warranties, again, disclosures kind of can be negotiated, accepted, not accepted. So over to you, Weber. I thought we'll just give a quick background and backdrop on this.
I know you have to rush through it because of the time constraint, but thank you for eloquently putting everything in a small box. Before I move ahead, I just want to remind, if there are any questions, please put in Q&A box, and I will take it up. George, my next question to you, when Uzeva was describing the reps and warranties, I remember whenever we used to negotiate, they used to say, I want to have market warranties, right? It's a very common word. This is market. This is what I want. And, this is a negotiation between the investor and the company asking what is market, right? And often the question is, what is market? And I want to come to you. You have done a lot of you had a lot of transactions, and you see what is market. So can you tell George, what is market for reps and warranty?
Okay, thanks, Vaibhav. That's putting me in a really tight spot, I would say. the candid answer to that question is that the market obviously depends on what the people on the deal team have seen. So if people have seen different types of deals, there's never going to be consensus on what's market. But leaving that aside, I think there are still some broad frameworks within which folks tend to reasonably operate, let me put it like that. So just diving into the buckets of warranties or indemnities that Josefa just spoke about, right? So fundamental warranties, I think it's pretty much become acceptable that the limitation would be on the deal value. So basically 100% of the value that's being transacted, because if title fails, then what you're acquiring is sort of is not worth what piece of paper that it was written on. So to that extent, I think it's largely become accepted that fundamental warranties are probably limited at the value of the transaction. Timelines is obviously another nuance that has to be dealt with, especially if there are financial sponsors who are on the cap table exiting their holding. The fund life definitely comes into picture. So how you address that, how you cater to that is a discussion on its own, and that's quite nuanced on a case-to-case basis. In some instances where, especially where you're taking a insurance kind of a solution, we have seen insurance being a good option to solve for fund life issues by taking a backstop based on insurance on fundamental as well. And typically that comes at a very small cost to the overall insurance premium. On business warranties, the general business warranties are usually in that, I would say, 10 to 20% kind of a value range. Again, I don't want to be held accountable to this, but that's again negotiated based on where finally people land up at. There are obviously exceptions to this, depending upon the specifics of the company, whether it's an IP-led business. We have seen different approaches being taken, or if there are material tax positions, then there could be different approaches being taken. But by and large, that's what I would have seen. Yeah, over to you, Vaibhav.
Maybe I'll come to Uday. We have just 5 minutes. I'll spend some time one last question to Uday, and then George, I will come with some of the questions from Q&A perspective. We'll try to finish in the next 5 minutes. Uday, recently there was a feud between Ashnir Grover of BharatPe with the investors and co-founders, right? In this kind of situations which happens, how do investors deal with it? Do they go back to the documentation and say, hey, this is what you had agreed in the documentation, or it is used just as a leverage point and you try to talk over the table? What exactly is the approach from investor, would take in situations like this?
Sure. So look, I can't talk about the specifics of this case, but I'll tell you the general approach is whenever there's a difference of opinion or a friction or a conflict created, it can normally falls into two buckets, right? One is when the investors feel there is an issue of intent. The other bucket is, sometimes the business doesn't do well, or you can't control the market, and there you may have kind of agreed something, and because the business hasn't done well, there needs to be a rethinking of even if there was something that was put in the agreement. And I think the approach is different depending on what is the driver, right? If the driver is the latter, it has to be a relationship-based approach. That is how we've always dealt with these kind of situations, and it has held us in good stead because remember, the founder's job is it's a very difficult job. It's harder than any of us. So you've got to be sympathetic of that if for some reason the business doesn't do well. But if it's an intent issue, then I think, it's, I won't, it'll be fine to go down the document and make sure that you get what you're entitled to.
Thank you, Uday. I think you rightly said the intent plays a major role, and often from investor perspective, always the question comes, should I, what I'm going to do will also not just reflect in this particular dispute, but also, it will affect my other investments. So how do you operate will become very critical. And if it's something which which you are doing because of the intent is something which will be taken well by the industry. With this, let me go to George, and maybe I will ask this question from Sneh to you, George. Sneh has asked question: how many companies actually offer vendor diligence? And the second question, which was asked was on post vendor diligence and corrective action, is a follow-on vendor diligence done? So basically, do people actually follow on based on the diligence? So
Yeah,
George,
sure. Yeah, sure. So quickly cover that. So I would say a very high percentage of companies do opt for vendor diligence. In our situations, as high as 90% plus of our transactions that we work on, there is a vendor diligence done. The extent of vendor diligence, whether we cover all aspects of diligence, varies case to case. But vendor diligence is very commonly taken up these days, and obviously that trend has changed over the years. But I think founders and companies appreciate the necessity of having it, if I may, to be more prepared, to be more ready, to be more efficient in the process. And on the second point, yes, there is always a follow-on diligence, but the level of that follow-on diligence is more crunched, more sort of tightly run, if I may, especially where there's a vendor diligence ongoing. So especially on financial diligence, right? So the vendor diligence may cover till a certain period. Post that, once we have sort of counterparties ready to go into the final stage, there may be a top-up usually required. But the follow-on diligence is usually quite limited and quite constrained in terms of timelines.
Thank you, George. Maybe Huzefa, you can take it up. The next question from Sohail, and maybe Uday or George, you're going to add. Feel free to add. What is the impact of disclosing an issue in vendor due diligence report, right, on insurance vis-a-vis taking a management representation on the same issue from founders? How would insurance company look at it when buyer seeks to obtain an insurance? Oh, I think we lost Huzefa. Maybe George, you want to take it up?
Yeah, I mean, to the extent I've seen, I'm sure Vaibhav, you can add to that as well, because I know you've done tons of work from the insurer side as well. So would love to hear your views on that as well. But yeah, at least what we have seen is wherever there's a matter which is disclosed in the diligence report, the standard approach that we have seen from insurers, that it usually becomes an exclusion unless there is contrary additional validation supporting that can be provided to sort of reduce impact of that issue, if I may, right? So it could be an opinion that is sought, or it could be a resolution of the matter based on recommendations by the advisor, etc. But yeah, that's at least my view on it. Uday or Vaibhav, if you want to add to that, please.
Yeah, Uday, you want to add from your perspective, since you may have gone, with the insurance sometimes. So, how do you?
Yeah, generally in the past, frankly, we have, for almost 17, 18 years of our existence, we were with the bank, Standard Chartered Bank, and we never resorted to insurance. So it's only in the recent last couple of years we've been looking at it. So my experience, to be honest, is limited in this. So I'll defer to your judgment.
Yeah, no, I agree with what George and Uday, both of you said. It's typically the moment you disclose, it's outside the insurance, right? And that's very clear. Insurance is not going to be, insurance company will not give anything which is already a known issue. So that's a basic thing. So if you disclose it outside, now point is that if you don't disclose, but if you are known, then also it can be outside, and it is a major issue because then you deliberately did not disclose and could be even fraudulent, so you can even lose more. So point is that when you know about it, you should disclose and you should adjust it, not really ask from insurance perspective. But with this, I think we are just over about time. We kind of started at 5:33 and we are at now 6:33. So thank you, audience. I'm going back to Arvind. Arvind, you take it up, and I know we have a coffee session after this, so feel free to join the coffee session. Arvind, over to you.
Thank you to all our lovely panelists. Wonderful thoughts have been exchanged. So look, the audience must know that now we're going to transition to Coffee Corner, and the NDA lawyers will continue and you can ask your queries. So that'll continue for another 20, 30 minutes. And if you like, please stay on and join the coffee corner. Once again, thank you to everybody.
George, please feel free to join the coffee corner. It's a time when participants can just interact with you. And I know, Nishith bhai, you are there. I'm not sure whether you are there, but do you want to say any last words? Okay, I don't know if Nishith bhai is there. Anyway,
No, I'm there actually.
Okay.
So there was some difficulty on, okay. So, no, wonderful to hear everybody. I think the whole process of due diligence undergoes change from time to time because the industry situations change, new industries come in. And most important thing for lawyers to understand is that with the changing time, new issues come up. And due diligence is just not about tick the boxes, where you started to tell in the beginning, and usual thing. But today it has become more of intelligence, and interpreting uh, uh, interpreting the facts in a way that the client is more secure. Of course, 100% security may not be there, but at least that would be very helpful. And am I audible? I hopefully, yeah.
Yeah, absolutely.
So I think it's the way in which we do that. In fact, one of the things we should be doing is before the start of due diligence, it would be good to have all hands meeting. And one of the approach that we have seen is that, when due diligence has to happen, some law firms would send junior members and to start as it is. Often the team that starts doing due diligence doesn't understand what the business is about, what the nuances, no briefing is there and stuff like that. So, quick short time they just do it. But it would be very important for every member of due diligence team to understand the business, the issues surrounding the business, and then do due diligence. That will become more relevant. Otherwise, it will be check the box exercise and then, risk arise at a later stage. And then, of course, it's a judgmental issue, the degree of risk and degree of seriousness that is where more application of mind is needed. But if the team understand all different issues to start with, then the junior most person would also know what the ultimate strategic objective is. And most of the time, uh, they do not understand strategic objective of acquisition, or the transaction, and that becomes a little bit of a problem because they are not able to contextualize what is relevant, what is not relevant. I think this is what something would be very helpful. Also, new age issues, as we discussed, like ESG. ESG is going to create quite a few litigations in the coming years. At the moment, it's a very much talked about. We do a lot of work, and to some extent, it may be hype, but greenwashing and many other things that are coming up. So we also have to look at the future issues and contextualize them to, while doing the due diligence. And it would be, I think, very important to take a holistic view, as was mentioned by Uday or George earlier, that, holistic approach is very important to due diligence. That is what is all diligence about. And I would stop here, but wonderful.
Thank you, Nishith bhai.
A wonderful discussion, and I thoroughly enjoyed. Most welcome to Coffee Corner now. I think there's automatic transfer to Coffee Corner. Arvind Bhai will tell, but most welcome to the, discussion room. Thank you.